Okay, Chris Speaks here today with Supreme Court Justice Will Sellers. He's going to sit down with me. First time I've ever had the pleasure of interviewing a judge, especially on the Supreme Court. So this has been an honor. How are you doing today, Judge?
I'm doing great. Doing great. Hope things are well with you.
Hey, man, things couldn't be better. It's going in the right direction. So, what made you decide to start to get into law to begin with?
Well, I guess when you're a senior in college and looking at different opportunities and things like that, I enjoyed constitutional issues. I was a political economy major in law school, seemed like the next step for me to pursue because I was interested in helping people, especially thinking through what the Constitution says and what people need to do to make sure their constitutional rights are especially protected.
Um, Interesting you said that. I've always found it fascinating the stories or the arguments about the founders and states' rights and the people who say the Bill of Rights are the only ones that uh, count. The other ones are unconstitutional. What's your opinion on that?
Well, I mean, it's not only the Bill of Rights, but there are other amendments that are there, and I mean, there's a procedure for amending the Constitution, and they were done, correctly, and so we have, all the amendments that are there. I mean, the Bill of Rights are important because it was the first comprehensive amendment to the Constitution, having the first 10 amendments, but all the rest of them are, they were enacted properly. So we,
So
we
when oh, I'm
those.
sorry, I didn't mean to cut you off.
No, I'm just saying. So you look at all those. I mean, they're passed appropriately, or they wouldn't be included. So
So what exactly before you became a justice? What area of law was your expertise in?
so for 28 years, I practiced tax law primarily in the Montgomery area, but really statewide, and did a few things in some other states, primarily in Alabama. So I handled litigation against the Internal Revenue Service, Alabama Department of Revenue, and then various counties and municipalities for clients that had issues related to whatever their potential tax liability was going to be.
Okay, so in did you have a political consulting company, or was you just a consultant? I seen where you ran Governor Iveys lieutenant governor campaigns for
Yeah.
in
So
2010
it's
and 2004.
it's just something that I just did. I mean, I guess one of the things that happened to me early in my career is one of my senior partners was involved in one of the first amendments to the ethics law, campaign finance law, and that kind of thing. And so I got to be fairly familiar with some changes that were made in those things. And so as a result of that, I had some clients that asked me to represent them in campaign finance matter, just to advise them how it worked. And one of my uh, clients happened to be the really she first ran for treasurer, and that was the
Right.
first race that I worked on. And so I had been her lawyer, and she needed somebody to help her, and so I was more than happy to kind of apply some of the skills that I had learned working on campaigns. I guess I've been involved in campaigns most of my life, so I've enjoyed doing that, and the rest is history, as they say.
So I mean, she first jumped in the governor's race, and obviously looking back, she made the right decision by
Right.
jumping in the lieutenant governor's race. Now, I mean, I didn't think she would win the governor's race when she entered it, and when she got in the lieutenant governor's race, I never thought she was going to upset Jim Folsom.
Right.
Um, did you believe she had a chance in that race? I mean, going into it,
Well, I mean, frankly, I did. One of the things that you learn to appreciate is having a good polling organization. And when she decided to drop out of the governor's race, we had two polling things we were looking at. First was, if she stayed in the governor's race, what would be her path to victory? And then if she didn't stay in that, could she have a chance at being lieutenant governor? And so we were fortunate to have Kellyanne Conway as our
oh,
pollster.
really?
And so Kellyanne, worked, with us. And so we did a poll, and we pretty much determined from that poll that the path to become governor was pretty steep and would require more money than the governor was willing to spend, but that the path to be lieutenant governor was a lot different. It was a really good election year for Republicans in the state. It was 2010.
So,
This
yeah,
was when the
Obama.
Republicans took over the state house. It was the midterm elections for Barack Obama, and working with some of the party folks that were recruiting candidates for the House and the Senate, we realized that if somebody was going to vote to beat an incumbent Democrat, they probably weren't going to vote for Jim Folsom Jr. They were probably going to vote for Kay Ivey. So when you looked at the polling data statewide, yeah, I thought she had a chance, or she wouldn't have done it. And then when you drill down further and looked especially at Senate districts and some House districts, you realize there were some incumbents that were probably going to get beaten. And as a result of that, we didn't think that people were going to go and vote for, a Republican state Senate or state House candidate and still vote top of the ticket Democrat. So it
Well,
worked real well.
I mean, where did her number stand at in the governor's race at the time? If I
I can't even remember. And it was, so at the time, you're looking at not only head to head data, who people are going to vote for, but how do you get your message out? And what would it take to get that message out? So it's not just a horse race. Is what do the numbers look like? But it's trying to project a path to victory.
I mean, 'cause it was
I
such
don't remember the exact numbers. I will tell you this, and it's one of my favorite, mementos. Is about a week before the general election, when it was Kay Ivey versus Jim Folsom Jr., everybody was kind of worried about it, and I had people telling me, oh, the polls look bad. And I think there was a poll in the Birmingham Post or Post Herald or whatever that showed Governor Ivey losing by about 8 percentage points to Jim Folsom Jr. And I just didn't think that was right. So I sent an email out basically predicting that Kay Ivey would get 52% of the vote in that general election. And I sent it out, and a friend of mine, her inauguration lieutenant governor, put it in a frame and gave my email to me that I'd sent about a week or two out, and that was exactly how she what the numbers turned out to be. So it was a good year for Republicans, but it was a good year for her, and we ran a really, really tough campaign against a very well-known opponent, and it was something that I'm personally very very proud of the work that we did in that campaign.
Yeah, because that governor's race was such a crowded field. I thought for sure it was Roy Moore's to lose that year.
Yeah.
And what you just said about that poll, I remember the last poll that came out um, before the Tuesday vote. I think it was on Sunday. It was Birmingham News, and you're exactly right. I couldn't remember if it was 8 or 10, but it had her down
Yeah.
by almost double digits. Yeah, I thought for sure that those polls would win. If I recall right, and you may correct me on this, Folsom led most of the night, and then all of a sudden, I guess the rural district started reporting, and he jumped to the lead, and never, or she jumped into the lead and never looked back. I mean, maybe my mind's for is that
Yeah, I
how? Is
don't,
that how,
it's one of those things. It's been, it's been about
yes.
13 years ago. I don't, but we felt good about it all. And I mean, one of the things that I do remember, when the poll, it was 7:05 and early results were coming in, they interviewed the governor, and she said, y'all just need to be careful. Don't be snookered, by the early poll results. And that was kind of a joke that we had about being snookered by the early results, because she ended up, doing, pretty well, all things told, considering who her opponent was.
Yeah, I mean, because you're talking about you defeated one of the oldest political families in the state. I mean, that was a monumental upset in my book to defeat Folsom. But yeah, I wrote an article one time about Jim, and he has been on the side of upsets in so many elections. He was the odds-on favorite to beat Jeremiah Denton in 1980. Right. Bob James pulled off an upset in 94. So Jim's had some bad luck in those close races. So in 2017, you got appointed to Chief or to Justice. What was it like going from being a lawyer to actually interpreting the law?
Well, it was different. I mean, I didn't really have any kind of transition, because I did, most of the time, and the governor's pointed this out, because she had the same situation, is, you're elected and you have a couple of months to have a transition and think through it and wind everything down. And basically, I got appointed, and the way it works is, you get appointed, and so you're sworn in immediately. So you have to start, you hit the ground running. You don't really have time to think about it. So, it took a while for me to get fully used to it all, because I had some great law partners, but I still had to go and, give them memos about all the cases and clients and things like that I had, so I could transition all those, because I had some great clients and all that, and I wanted to do right by them. So I felt like for the first maybe 6 months or so, I feel like I was working a couple of jobs trying to get all my client files transitioned, trying to take on the new responsibilities of the court, and then trying to do just the normal things that you do in everyday life. So I mean, it's clearly different from private practice, because when you're a lawyer, you're an advocate for a client and for a particular cause, and when you are on the court, you're not really an advocate for anything but the law, and what does the law say, and how does the law deal with a particular issue. Either what does legislation say and how do we interpret it, or what's the history of legal proceedings on a particular issue. So it does take a while to kind of transition mentally, so that you don't feel yourself as being an advocate for one particular position, but you look at the law, you look at what the arguments are on either side, and then you make an interpretation of what the law says and how it resolves the issue that's presently before you.
Speaking of that, interpretation of the law, we hear this thrown out like both sides, liberal judges or conservative judges. I mean, is there really such thing as looking at it liberally or conservative, or justices just have a different view when looking at things? Does that question make sense?
Well, I mean, I think what you're really saying is they're judicial philosophies. And
Mhm.
there's certain judicial philosophies that say, what's the tradition, what's the history of these legal provisions. I mean, the law that we have is not like only law because the legislature passed it. It really goes back hundreds of years to really, the Magna Carta, which is 1215. So we're talking about 800 and, some odd years of how the law develops and how courts ruled and that sort of thing. And so I think when you talk about conservative jurisprudence and conservative judges, that goes back to, do we look at the history of the law and what the law meant and how it delivered and interpreted and gave us these freedoms, or more liberal judges who are frustrated with the world around them and they want to use the law to become more of an advocate for a position and interpret the law as being a lot more fluid and not being anchored as much as I think you should be to the history of different provisions. And what interpretation of the law has developed over hundreds of years, and a lot of those ideas of how to interpret the law are still absolutely as sound and as relevant now as they were hundreds of years ago. And so I think conservative judges look back at those things to give them insight, whereas a more liberal judge might think, well, I don't really need to look back to that. I can just simply make a decision on what I think is right and what's the best, and not look at the law as it has developed over hundreds of years.
So I've heard the term thrown out by politicians. Um, they get mad at a judge ruling or something. When you hear the term legislating from the bench, is that really fair to say to a judge when they overturn a law they see as unconstitutional? I mean, how is that
I mean,
legislating?
so legislating from the bench, when it's used, is really having a judge, what I would say is superintend the legislature and substitute his view for whatever the legislature did. I mean, there's sometimes that people don't like laws the legislature passed. And so rather than deal with what the legislature passed and try to interpret it, it's easier to say, well, this is unconstitutional and here's what the law ought to be. And so when we say somebody legislates from the bench, they mean that they're ruling based on what they think the law should be, not what the law actually says. And so that tends to be the difference. But the other issue is, we have this body we have, an Alabama Constitution, a federal Constitution. We have statutes that go way back. And so the legislature sometimes will do things, and we have to declare the law unconstitutional because it's incongruent with maybe what an Alabama or federal constitutional provision says the law ought to be. And so that's not necessarily legislating from the bench. And that's why, when we, especially in our court, our opinions are all written. So we explain what it is that we do. I was telling the group several months ago. I said it's kind of like, you learn long division in the second or third grade, and you have to show your work. You don't just give an answer, you show your work. And so our opinions are basically showing our work. So if we declare something unconstitutional, we want to be very careful, because we want to respect what the legislature does. We want to respect that they're duly elected to do certain tasks, but they're not elected to pass legislation to do whatever they want to do. Legislation is confined and restrained by the Constitution. And so if they wander off from the Constitution, then it's the court's job to declare something unconstitutional. But we explain why it's unconstitutional, so anybody looking at our decision can see that it makes sense that we've declared it unconstitutional. We haven't just done it because we're trying to substitute our judgment for the legislature.
So let me ask you your opinion on this right here. And I think you can, if you can't answer it, I understand. This. Sorry, I had a phone call come in. A relative of mine got stopped with four other people, and they had she had a small amount of methamphetamines on her, and she throws it out. The police didn't see it, but I think it was on the side of the it was on the in the grass beside of the road, and so they arrest all four people because nobody takes nobody owns up to it, and she goes out. I guess her daddy had the money and hires the drug lawyer, the guy that you go get if you're charged with a drug crime. So he makes a motion to suppress because it was found on state highway. And in his motion to suppress, he said the drugs could have been dropped by anybody. Sorry, phone call keeps coming in. So anyway, he made a motion to suppress based on where it was found that anybody could have left the drugs there. And the judge granted the motion to suppress, and the case was dismissed. Does that follow? I mean, is that because I hear about cases where they make motions to suppress all the time. How does something like that follow under the law?
Well, so here's what you've got. I mean, yeah, obviously, when you have a criminal proceeding that has the potential to deprive somebody of their life or their liberty or their property, we take extra special precautions, which is why people are presumed innocent all the time. That's one thing our court system does. So we give trial judges the discretion to look at things, and if there's a motion to suppress, they have to consider whatever the evidence is there, and sometimes motion to suppress evidence is granted because the judge finds and makes certain rulings that the evidence that was found it wasn't obtained appropriately, or there may have been an issue about the custody, or there could be any number of things. So the whole idea is we want to protect people's liberty interests. So we give them every benefit of the doubt. And if there's a question that some evidence may have been procured improperly, then we charge our trial judges, who are also elected, to make decisions as to, is this evidence appropriate? And even sometimes if evidence is appropriately obtained, it could be restricted in how it might be introduced at a trial. So we give judges that discretion. If they've abused that discretion, then people can appeal it to the Court of Criminal Appeals, and then they could ultimately appeal it to us to look and see, did the judge abuse that discretion and did things inappropriately. But that's how our legal system works. We want to presume people are innocent. We give them a lot of benefits of the doubt, and we require that the state through the district attorney puts on the evidence to prove beyond a reasonable doubt.
So let me tell you two instances happened to me real quick. Something like that. I got stopped one time, and the officer or deputy walks up and says, "Step out of the vehicle." So I complied, and he says, "Step to the back of the vehicle." Again, I complied, and he starts just patting me down. And he says, "Do you have any weapons in the car?" I said, "Yes, there's a 38 revolver inside the door handle there." So he gets it, starts running it, and I said, "I still got hands on the back." I said, "Deputy, would you like to see my license and concealed carry permit?" And he looked at me like I had two heads. And so he says that he set the gun right beside me, and then goes back and just searches the vehicle, comes and pats me down again. and goes back to the vehicle and says, "Tell me where the drugs at, or I'm going to call the dogs out here." I said, "We'll call the dogs out here." You searched me twice. And he said, "Where are you going?" I said, "I'm going to get a tire over at this tire store because I had a donut on there." I said, "Why'd you stop me and search me like that?" And he said, you didn't have your seatbelt on. Is that a legal search and search and stop and
It's
search
hard
somebody
to,
like
I
that?
mean, so I mean, obviously, when you're on the road or whatever it is, you can get stopped for any number of things. As a question of, it could be whether it was, reasonable or not. I don't know all the circumstances.
Yeah.
Typically there's some showing of probable, cause. There's a tail light that's out, expired plate, or whatever it is. It could be that, I mean, it happens every now and then that there's information that comes in about the description of a car that was maybe seen. So, I mean, if you pressed it further and the officer had done something, you can't, they can't just go and stop people, willy nilly. There has to be at least some reason for doing it. But the same thing is that if you're driving, a car, just like you have a license and things like that, certainly you subject yourself to, having a patrolman, stop you to, check your license to make sure, you have a valid driver's license and things like that. So it's hard. I mean, there's so many things that go on every day, and we clearly want to give law enforcement the benefit of the doubt and give
Oh,
them as much
absolutely. Yeah.
discretion as they can, because they may be stopping people for different for reasons that we don't maybe understand exactly what they are, but they are allowed a great deal of latitude to try to maintain public safety.
Because then a few months ago, I had dealer tag still on my car, and I got stopped and pulled over, and talking to the deputy, asked for my license, and I complied. Again, yeah, I've always found it's better to comply, no matter any situation. Everything's going to be fine. So he comes back and runs me, and he says something like, "Okay." And I always find it funny how when officers phrase this question of, "Do you have anything on you that I need to know about?" like somebody's going to admit that. Of course, I don't. I said, "No." I said, "I don't have anything." He said, "Then you wouldn't mind if you got out and I patted you down?" Well, I've got spinal stenosis so bad, and my back was hurting, and ordinarily I wouldn't care, but I said no, and he said, "No, I can't. You don't mind?" Or, "No, I can't pat you down." I said, "No, I'm not consenting to a search," and he said, "Okay, have a nice night."
Yeah, I think that's a situation where maybe he knows what the parameters are, or whatever it is, and if he thought there was something inappropriate going on, he could have taken it a step further. So,
So, when somebody goes through the judicial system and they are convicted of a crime, uh, the first step usually is to ask the judge for a motion for a new trial.
I mean, it could be there. There could be a lot of different things that go on. I mean, sometimes people plead, guilty, but in their guilty plea, they may reserve an issue that they want another court to look at. And sometimes people do apply for a new trial. Sometimes there may be another motion that they may file, after the trial, and different things like that. So there's never, I mean, I'd say that's probably typically what goes on, but there are also other things that people might do, depending on what the issue is. Was it a jury trial? Was it just a trial by the judge? I mean, there are any number of things like that could potentially happen. But our criminal justice system is set up so that there are a number of safeguards that even after somebody is convicted, they have a number of opportunities to petition a court to review their case on a direct appeal, to review the behavior of their lawyer, to make sure that they had adequate representation, and any number of things like that. So, within our criminal system is built in a number of safeguards. So even though somebody's convicted, that's not necessarily the end of the judicial process. There are other ways they can take advantage of the court system to have a court review their conviction and review other things about it. And then it happens every now and then where there's new evidence that may be discovered, and that we have a procedure in place so that people can petition a court to reveal what new evidence there is that might exonerate them. And so we have
Okay.
things built in like that so that nobody's going to be convicted and there's no recourse. There's recourse all throughout our system.
that answered one of my questions. So the next one is when they if the, which most times I have actually read a few where a judge overturned it, but and or granted a new trial, but it goes to the criminal court of appeals. Now, when it goes to the court of appeals, they're not actually looking at evidence, right? They're looking at if the trial judge made an error, or if there's prosecutor misconduct, or if the inadequate counsel, or something that violated the defendant's or the convicted's rights. Is that correct?
So there are really two things. So initially, when there's an appeal, somebody's been convicted and there's an appeal, and they're going to find reasons that they should be successful on the appeal. It could be any number of issues. Was a jury instructed improperly? Were there jurors that shouldn't have been on the jury that should have been struck? Were there people that were struck improperly? There are any number of things they might do. So when they initially appeal, they would put forth whatever those particular deficiencies they found in how the trial, was conducted. Was this evidence inappropriately admitted? Was there testimony that should have been excluded? And if that testimony had been excluded, they might not have been convicted. So the initial review is to look at, and it is to review what the trial court did. It's to look at the transcript, to look at the evidence, to look at everything, and based on what the appeal is about, to figure out, well, was there a violation? Was evidence submitted inappropriately? The catch-all is, was the evidence sufficient to convict? And courts will look at that. After the Court of Criminal Appeals has looked at something and somebody is still dissatisfied, then they can appeal to us. But their appeal to us is a little bit limited, because what they have to do is they have to show us that there's a conflict in how the Court of Criminal Appeals decided that is in conflict with maybe other cases that we've had, or it may be that there's a novel issue. It may be that the statute they're convicted of is only a recent statute, and we need to look at that in particular and reinterpret that statute to see if they were appropriately convicted. So there are a number of levels of appellate review that go to both how the trial was conducted, but then ultimately looking at the evidence to make sure, in some degrees, was the evidence going to be sufficient to convict somebody of the things they were accused of doing.
Okay. I forgot to ask you this question before I moved on to that one. So let me ask this real quick, and then talk about the Supreme Court. I remember, and you may remember this happened. I only heard of it once. It was this case like 20 or 30 years ago, this all pair case, and the jury convicts this girl of murdering a baby, shaking her to death, and the trial judge renders a verdict of not guilty from the bench and overturn the jury's verdict. Does the prosecution have an appeal at that point to overturn the judge's? No.
They could appeal that. I mean, because if the judge is substituting his judgment for the jury, and we want judges to do that, because judges are supposedly, learned in the law, and they can see that there could be times when, based on the facts of the case, a jury could be inflamed, or a jury could act more emotionally than they should, and the judge is there to maybe temper that, to say, well, the law on this issue is pretty clear, and the law is not sufficient to support a conviction. It doesn't happen very often, but we do give judges the ability to do things like that. And sometimes what will happen is a judge may go ahead and let the jury return a verdict, and then the judge can overrule that, and then the case could come on appeal, and we already have the jury verdict in there. So if we reverse the trial court, then we would reinstate the jury verdict, basically.
Okay, so you probably interesting question about the statute. From my understanding, the Supreme Court doesn't have to hear every case. They pick certain ones to hear.
That's really the U.S. Supreme Court. Our court has to hear every appeal that's filed. We have to deal with in some way. There's some cases that we have, a more significant opinion that's rendered, but every appeal that gets filed with us, we have to rule one way or the other. On the U.S. Supreme Court, they may have a lot of petitions, but they don't have to grant every petition, because they have discretionary jurisdiction. They don't have to take every case. They have the absolute discretion to decide what case they want to take. They could take more cases. They could take less cases. Basically, the U.S. Supreme Court on an annual basis takes about maybe 65 or 70 cases. Our court,
Wow.
is a little bit different. We have maybe about 1,000 cases that we would deal with on an annual basis. Our numbers
Oh,
are still
wow.
down from COVID, but we have to deal with all those and render a decision in each one of those cases to either affirm the trial court, to reverse the trial court, or to do a hybrid, to maybe affirm part and reverse part, that kind of thing. So we don't have the luxury of
That's a
just
lot of cases.
deciding
Yeah.
what we're going to do. And some are easier than others, obviously, but we have a pretty heavy workload. In the Court of Criminal Appeals, even more so. They
So,
don't have a choice. I mean, when the Court of Criminal Appeals gets an appeal, they have to deal with it. They have to render a decision one way or the other. They don't have the luxury of saying, well, we're just not going to do this today.
okay. So, do you remember the when Doug Jones brought the church bombers to trial back in 2001 or 2002?
Just
Thomas.
what I remember in the newspaper, yeah.
Okay. Well, Thomas Blanton, they had entered in some evidence against him called the kitchen sink tapes, and the FBI had bugged his tapes from an adjoining apartment, and I can't remember how, but it went. Robbins ended up appealing it all the way to the Supreme Court because he set up under the 1964 statute that was illegal, but since it had changed, then they made it admissible in court. Um, it, um, or it could have been the other way around. How does that work if something was illegal at one time and legal now? Um, that it's not ruled on for
Well,
what?
so it's always a difficult thing because the law, laws do change and criminal laws change, and
Mhm.
it's hard to say there's a hard and fast rule. Our biggest, the overriding rule is this: is that people are presumed innocent until proven guilty, and that most of the time statutes are not retroactive, so that when you pass a statute, it only looks to the future, not necessarily to the past. However, unfortunately, in different situations, which is why it's hard to give an answer, there are some times when things can be retroactive, depending on, is the retroactivity trying to fine tune something? If the retroactivity is completely new, then it may not be appropriate to do that. But typically, when somebody is convicted, you look at the statute that they violated that's in place at the time of conviction. But we do have change in the statutes, and that makes a difference. But in most circumstances, you look at, I mean, and when I was a tax lawyer, this was especially important because you look at the law in effect in the year that the taxes were remitted. And it's the same thing generally that's true in criminal matters. I mean, there are always there can be some exceptions to the rule, but that's basically how that would work. And so I don't know the particular instance of what that of that case, but normally you would look at what is the law in effect on the day that the crime was committed. Now the other thing can be, though, but there may be issues that are related to when the crime was convicted, but when something goes to trial, there could be rules that relate to administrative issues and how a trial can be conducted. And if that's the case, then you would look at what's existing that the trial court has to do when that particular case is actually being tried. So you've got to balance a number of different timelines as to what's the law on conviction, and then what administratively can the trial court do or not do when a case is actually tried. And the big picture is we don't allow what we call an ex post facto law. We can't basically enact something that makes you guilty for something at the time you did the act was not illegal. So sometimes the prohibition against ex post facto laws can mean that a prosecution would fail because at the time the crime was committed, what was done was not actually a crime. So the legislature has to live within those parameters.
Okay, so I got one more question about that one, and then I want to move on to another one. We're guaranteed a right to a speedy trial.
Right.
So in their appeals, uh, both Blanton and Cherry, they said their right to a speedy trial was denied because it was almost 40 years later. Is there a time frame that is gone by, or I mean,
So there are a couple of things. So there are different statutes of limitations for different crimes.
mhm.
Um, we do that to make sure that witnesses are gone, evidence is gone, and things like that. But there isn't a statute of limitations for murder. Typically, there
Right.
is no statute of that, and so that's why if somebody's been murdered, that statute of limitations never really closes. But so you've got the statute of limitation. The other thing that you have is, yes, you have a right to a speedy trial, which means that at the time, once you're indicted and you're arraigned, then there are certain procedures that go in place so that you would have a speedy trial. And the idea there being, as I mentioned before, is, there's evidence that's there. There are witnesses. And so the sooner you get the evidence and the witnesses together as close in proximity of when the crime was committed, you're going to preserve those sorts of things. So we do have a right to a speedy trial. And if somebody has violated that, and if the state has taken actions to delay the trial for no appropriate reason, then yes, I mean, that can be thrown out. But a number of times people want a right to a speedy trial, but they may be the ones that have taken the time. It could be that there's the defense lawyer needs more time to develop evidence. Well, if they've asked the trial to be continued, it's hard to come back in at a later date and say, well, you should give me a speedy trial. And the judge would say, well, you're the ones that asked for additional time. So there's some balancing tests that you look at when somebody claims a right to a speedy trial, but there are different timelines between when can somebody be indicted and when they can't be indicted. What's the statute of limitations? The other thing is, but once they are indicted, then how quickly must the trial be brought, and can you continue the case? And in instances where the state has found to have done things to delay intentionally or delay in such a way that's prejudicial to the defendant, then those indictments can be dismissed, and the case will be thrown out.
Okay. One other question about that, because I forgot about this one here too. When I've interviewed John Robbins about this case, he's talking about one of his appeals was uh, it was we're supposed to have a jury of our peers, and
Mm-hmm.
one of the things he brought up was there was no white males on the jury.
Yeah.
How do we judge what a jury of your peers is?
Well, I mean, so that's always an interesting thing. There've been cases about that. A jury of your peers, that means somebody that's exactly the same socioeconomic status. And typically, no. I mean, the whole idea is there should be a jury that's made up of an appropriate group of people from the jurisdictional area where the trial is going to be held. So you're not entitled, if you're a white male aged 35 to 45, to have all white males 35 to 45. The idea is that you want to have a jury that is composed of people that are a cross section and representative of the community to understand what normal community standards were, that can basically listen to the evidence that's presented and basically make findings of whatever the facts are. So the idea of a jury of your peers being somebody, 12 people are going to look exactly like you or live in your same neighborhood, or that's not really what that's all about. The idea, I would say the word, peer is probably very broadly defined as people within your respective community that have the ability to make factual findings based on the evidence that's being, presented, which is why when you have a jury, everybody has the ability to strike certain jurors. The court has the ability to remove certain jurors for cause, and then lawyers and defendants have the prosecution and the defense have the ability to strike certain jurors that they may have an issue with.
So after it gets to the Supreme Court upholds the only other route then is to petition the court of federal courts to look
Yeah,
at it.
the next thing, if somebody disagrees with what we've done, then their only route of appeal is to the United States Supreme Court.
Oh, it doesn't go through sure. Okay, I thought it went through the.
Well, it can get confusing because what happens is, especially in death penalty cases, because those get a lot of coverages, what
Yeah, that
happens
was
is
going to be my next question.
a
Okay,
person
go ahead.
will apply to usually a federal district court based on cruel and unusual punishment, constitutional issues, and things like that. And that's really a new case. The federal district court is not looking at the Alabama Supreme Court's decision. They are looking at at other issues that are more constitutional in nature, that are basically a completely new review of the case. So they're not really appealing our decision. The appeal of our decision can only go to the U.S. Supreme Court. Now, the federal district court might use some things from our decision, but they don't have the ability to reverse us per se.
So that's what I was going to ask you about with the death penalty cases. Uh, when they come before you, it seems like everything that I read, the argument is always the same: cruel and unusual punishment. That their veins are can't handle this, and it's cruel. Is that the main arguments they have, or do they try
Oh,
to break?
they're all kind. I mean, I think there are any number of arguments that you get. I mean, the cruel and unusual relates to how the death penalty is imposed, but there are other things during the course of the trial that could be there. Did the prosecutor, say something that was inappropriate? Was there evidence that wasn't introduced properly? Was there testimony that the judge should have thrown out? Were the jurors, was the jury properly, assembled? Were any jurors, did the prosecution strike jurors for inappropriate, reasons to try to change, say, the makeup of the jury, the racial makeup or something? So there are a lot of different issues that they raise on appeal, and it's much more than just, is the death penalty cruel and unusual punishment? A lot of it has to go with the underlying case, the conviction, how the conviction was obtained, and anything related to that.
Um, okay, so I got an interesting question for you about with jury trials. My dad, years ago, he hung a federal jury.
Mm-hmm.
Him and another man did. It was a drug trafficking case. I think they had to go to Tuscaloosa, and the verdict was 10-2, with them two voting for acquittal. And I said, "Well, what was you basing it on?" He said, "Well, he said the other three had pled guilty and testified against him." He said he was claiming it was them. I don't know who's telling the truth, so I wasn't going to convict. So, okay, fair enough. So how often do you think that the prosecution is going to bring that back up to trial? Do they automatically file for that, or just say,
So I don't know that I would necessarily have those numbers. I mean, the district attorneys would know that, or the U.S. attorney's office would know that, because we wouldn't necessarily see that, and that wouldn't come up in our court statistics.
right?
I mean, you hear about it and it happens, but I wouldn't necessarily know how to give you an idea of if that happens, once out of 100 cases or 10 times out of 100 cases. I just don't. I just really don't have that information to know. But again, the jury trial is done that way. I mean, you have to have unanimous, the jury has to decide unanimously, and that's part of our criminal justice system, to protect individuals from, losing, their life, or losing their property, or losing, their liberty. And so it's a pretty high standard, and other countries don't necessarily require that, but have 12 people all agree, yes, you're guilty of this.
Yeah,
That's why a lot of times it makes it very difficult for a case to be reversed.
yeah. I'm a big trial buff, and back when I'm sure Robert Blake 20 years ago, when he was accused of murdering his wife, I kept up with that every day, and they acquitted him on murder, one count of solicitation murder, and the jury was deadlocked 11-1, acquittal on the other one. But they were out for 19 days before they finally reached verdict. Does most judges let them keep deliberating that long before they just declare a total mistrial? Because that just seemed like an enormous amount of time.
It's in the discretion of the trial judge. I mean, typically when a jury is out that long, there'll be some communications with the judge. Do they think they're making progress? Are they hopelessly deadlocked? And if a jury comes back and says they're hopelessly deadlocked, then there are things that a judge can try to do to try to break whatever the deadlock is, maybe by giving them, recharging, or rereading the jury charges to them, explaining them other things. So it all depends on what a trial judge, believes. And if a foreman comes and says they're hopelessly deadlocked, a judge can accept that and dismiss the jury, and it can be retried. Or the judge could say, you haven't done your duty, you need to go back in and continue to work on this. So a lot of that can be on who the judge is and what they think about the case.
Yeah, I've seen that on a crime show the other night where they told the judge, like, twice they was hopelessly deadlocked, and he kept sending them back. And they said, "Look, we're not going to reach a verdict on this," and finally, declared a mistrial. So, let me ask you some tough questions here. I don't need to put you on the spot. Um, do you think that it's better for judges to be appointed or to be elected? Because obviously PACs are going to try to influence elections. And then what if a judge or jury, I mean, excuse me, justices make a ruling that is constitutional, but the voters don't like it, and then they get voted out of office? That is just the election part of it seem more unfair than being appointed,
Well,
or I mean,
so
being nominated.
in the United States, every state is allowed to figure out how they're going to pick their judges. Federal judges are appointed by the president with the advice and consent of Congress, and once they're confirmed, they're appointed for life. You can only remove them, for misconduct, and they have to be impeached. So it's a pretty high standard. In Alabama, we were a territory for a number of years, and when you're a territory, the federal government appoints judges to hear the case. And I think people don't like to have judges that are appointed. I think Alabama and other states are very populist, and that we think electing judges is the best way to go about it. It causes judges to be perhaps more accountable to the general public and things like that. So in Alabama, that's how we've chosen to do it. And all of our judges, from probate judges to district judges, circuit judges, appellate judges, are all elected by the general population. Obviously, a probate judge will be elected by the citizens of his county. A circuit judge by the circuit. District judges typically from on a county basis. But that's how we've decided to do it. And you can look at different data. I mean, every now and then people send us studies that they've done about, well, does electing judges mean that these judges are better than judges that are appointed? And it's like anything else. Once you pick a method and you stick with it, the results are going to be pretty much the same. And we've had federal judges that have been, impeached for bad conduct and things like that. We've had judges in Alabama that have been removed for bad conduct. So there are a number of things that are set in place to make sure that we're accountable to the population. I, as a state judge, I'm elected. I think that system seems to work okay. I'm not for changing it because I don't think the general public would want it to be changed, and it would require a change in our Constitution to do that anyway. So that's the system we have. And, it could bother some people that there are, political parts to that we have to run for office and things, but it all evens itself out. And I think the idea is you can be an impartial, judge, even though you have to run, in a contested election. So I don't
Yeah,
know that necessarily, matters. If you get a panel of federal judges and state judges, everybody will have, a different opinion about it. But that's the state of Alabama, for whatever reason, has chosen to elect our judges and to have us run every 6 years, and that system seems to work. So,
well, I definitely think that on the federal level, people shouldn't sit on the bench for 60 years. You know, like I think there should be some kind of limit on that because what that get up close to 100. But so let me ask you this, Judge, and um, this is kind of a tough question. So there is, and I look on the Secretary of State's website. I do different candidate or officials all the time. There are PACs that have received money from the Porch Creek Indians
mm-hmm.
and have given to legislatures, justices, attorney general, governor. Um, does that not create a conflict of interest when legislation and court decisions are made on that?
I mean, like everything else, I guess the answer is it could, but I don't think it does. I think the issue is if you had somebody in a judicial race and their contribution was so significant, it amounted to, let's just say, 50% of all contributions, that would be that's a potential problem. I think if you looked at most of our campaign finance reports, you're not going to find any one organization, PAC, lobbyist, individual that's going to give 50% or let's say 25%. Most judicial races, campaign finance report disclose a pretty large group of people that have given money. So there's no one group that can say, well, I gave them so much money that they're probably going to rule in my favor. And I think that's what, when you look at cases that have looked at whether judges should recuse themselves based on political contributions, it's got to be so significant. And I would think that any candidate that gets a contribution that's that significant is going to probably say that's too much and send the contribution, back. But like anything else, sure, people can be, influenced. But the difference between a legislator who basically is in the legislature to represent interests, to draft legislation, it's a little bit different because they do have lobbyists that are trying to help them write legislation that their clients want to. Nobody lobbies us for our opinions to say, we want you to write an opinion that does this. They're basically electing us on our judicial record of that they think that we've got the legal ability, that we've got an appropriate track record, we have the requisite education to be able to look at cases and make a decision. But nobody's lobbying us to say, we want you to specifically rule this way on this type of particular cases, because if they do that, then that's way outside the bounds of appropriate conduct in dealing with a judge. And I think all of us are very aware that we don't have conversations like that. And if somebody pressed us that much, they could put us in a position where we might have to recuse, or if somebody gave such a significant donation where it completely represented such a huge percentage of overall contributions, that then you would have to say, I can't sit on cases if I'm going to take this contribution.
And I may have asked that question unfairly, and I didn't mean to, because some of the PACs were receiving money from other entities. So that doesn't necessarily mean that Fort Creek Indians money actually went to, a certain elected official. So I didn't want you to think I was being accusatory or anything like that.
No, I just
okay.
It's how it is. I mean, political action committees are set up, and we've said that that's appropriate for people to band together and pool their contributions and support one candidate. The problem you get is when the contribution is so significant and such a large percentage of overall contributions that it's disproportionate. And I think when you have that happen, it really does beg the question.
How hard is it to deal with the Alabama Constitution with 30 amendments? I mean,
it's got more than that. I think it's maybe up to 4. It's 700 amendments. It's not.
Oh, is it 700? Okay.
I'll have to go look, because we recompiled and we shut down some of those. But that there was conjecture that Alabama has the longest constitution. It's really not that hard, because most of those constitutional amendments are local amendments that basically give an expanded right to a particular county. So it's really not that hard to do, because we're dealing with the main portions of the of the Constitution. We're not trying to. It'd be one thing if all those sections all involve the same things, but a lot of times they don't. And it could be that some things are repealed, and yet even though an amendment is repealed, it's still considered to be an amendment. Now, in last year, 2022, we recompiled the Alabama Constitution, so it should make it a little bit easier for everybody to go through it.
So, I got let me think of a funny story. Tori King told me one time. In a couple of days ago, General Marshall shut down Whitehall based on the September 22nd or 22 ruling. And from my reading of it, the Supreme Court made the decision based on how the law was written. It was the correct decision. And Judge Marshall, or General Marshall, did what he did, was bound to do by duty, and upheld the law by closing them down. uh, to tell you that story about what Troy, I asked Troy one time, I said about when he was going after the sex toy stores, and Troy cut me off. He said, I didn't go after them. He said, that was something that was initiated by Bill Pryor, and it was a stupid law passed by the legislature, and it got dumped in my lap, and I had to follow through with it. so my question is, and I don't know if this is one you can answer, do you think the legislature needs to revisit that law?
Well,
the
I mean, I don't really know. I mean, if you look at news or whatever it is, it seems to be that every time the legislature meets, they're typically looking at legislation that relates to gambling or whatever it is. And our job is to simply interpret what the Alabama Constitution says. And since we've done that, it's hard. I just don't think I can comment on particular cases because I don't really know all the facts and circumstances of what it is. And I have a lot of respect for journalists, but sometimes journalists don't get the story completely
right.
correct, and there may be other things. And so since gambling is a critical issue that we seem to see a bunch, it's probably not a good idea for me to comment because I don't
I
really know
understand.
all the facts, and it could come to us, and then we'd make a fair decision based on what the law is and what the particular situation is, but I don't really know about that. And I
Yeah,
probably
because I defended the Supreme Court. People were arguing that I was defending your decision and Judge and General Marshall. I said, look, this is how it's written. They had this they upheld it by the way it's written, and he had to uphold his duty as the Attorney General, as the chief law enforcement officer.
yeah.
So if you want to go back to the legislature, if you want it rewritten, but it's not the justice's fault. Let me ask you one question. In your opinion as a judge, um, is do you? I feel like that there needs to be some kind of reform in our criminal justice system, especially when it comes to like the legalization of marijuana. Think that's such a draconian law now, um, with the especially like with what Colorado's doing, the tax revenue. Do you think it's time that that law was revisited and decriminalized,
I
or
hate to
should?
say it, but so Alabama, of course, did do some things, and has this commission that's looking at medical marijuana, and
Mhm.
I know there are cases pending on that, and so I probably shouldn't answer that either
Okay,
because I wouldn't
I
want to have
understand.
to recuse myself because I know there's been some potential changes in how that works, and I haven't looked at the law, and it might come before me, so I'd better not comment on that.
I understand. I was just talking to some lawyers about that earlier. So this is your first time up for reelection because you was or did you have to
That's
run
my
in two?
second. So I was appointed by the governor in 2017, then I ran in 2018 and was elected, and then I'm up in 2024.
Okay, so 2024. So does Justice Sellers have any ambition for higher office? Like,
Nope, none whatsoever. I thoroughly enjoy my job. I enjoy coming into work at our courthouse every day, and I have no desire to do anything other than stay on the Alabama Supreme Court for as long as the citizens of Alabama will let me serve. It is a wonderful job. It is a high honor. I am grateful every day that people have let me do this. I'm glad that I don't have any Republican or Democratic opposition. I'll still be on the ballot in 2024. But I have no desire to do anything other than continue to what I'm doing. It is a great job, and I thoroughly enjoy the work every single day.
um, so two more questions for you because I know you're a busy man. Um, what was your opinion? And if again, if you can't discuss this, I understand. The redistrict, um, gerrymandering of our districts down there. I mean, what was that? I
So
mean,
that's
all
really a
the
federal issue because there's the Federal Voting Rights Act, and there's a suit that was brought under that Alabama had drawn their districts, inappropriately, and so the federal courts review that. I don't know that I really got an opinion on it. The legislature has an opportunity to redistrict. They do that. Uh, People have a right to object to that and make sure that their rights are fully considered and vindicated. So, I mean, that's just kind of the way it works. And every 10 years we have to redistrict. And the one thing in all this redistricting that I think people have lost sight of is that Alabama came within an eyelash of losing a congressional seat. And instead of having 7 congressional, if we had gone down to 6, it would really have been extremely difficult. And so one of the, it's kind of like the dog that didn't bark, or the thing that doesn't happen. I don't think people realize how close we came to losing a congressional seat. And I'll have to hand it to the current administration, just the job that they did of making sure that everybody filled out their census. Because had they not done that and we'd gone from 7 to 6, it would have created any number of problems for everybody, because it wouldn't be just simply changing a few lines here and there. It would be a wholesale reordering of our congressional things. And so while the redistricting is what it is, people should be very thankful that they had some smart administration and strong leaders who were doing everything they could to get people to fill out their census form, because we need 7 congressmen, and we certainly don't need to lose one and go down to 6. And that, I think, is maybe one of those untold stories of the 2001 timeframe. Even in the midst of COVID, we managed to get everybody to sign, to fill out their census form, and so we didn't lose out. And it could have been catastrophic if we hadn't have done that, and we'd be a completely different discussion.
My concern is the ruling, and I understand the percentages. I think the black population is 26%, and 7 districts. I understand making another minority. I understand the argument making what is another minority, majority, or however they phrase it. But where does it end? I mean, what happens if the Asian community in Los Angeles sues for a seat, or the LGBT out of San Francisco says they're not representing, they sue for a seat? I mean, could this possibly happen? Where
so there's some very interesting nuances with the Voting Rights Act and how it applies and who it applies to and things like that. I'm not so sure how it applies specifically to California in the same way it might apply to Alabama. But the idea is, when the census comes up every year and congressional seats have to be awarded, and then the legislature has to redistrict, you take all those things into consideration, but you don't want to draw districts simply based on, race or any number of things like that. You want to draw it, so that they're neutral reasons. And I think there's a lot of good evidence to say that, the way that the districts ought to be, congressional districts, state Senate districts, state House districts should be in a way so that's representative of the general population that are going to vote to send their representative in Alabama to Montgomery to make decisions, and to Washington. So I think you want to look at that, and I think courts are going to make some decisions about what that looks like. But I do think that I think it makes sense under federal law that there's some deference that's given to what the legislature does, because they're closer to the issues, and I think they're in a pretty good position to make some decisions of how that should look.
Okay. Well, phone call keeps coming in. So when you mentioned earlier that y'all have 1,000 cases that come before you a year, man, that's a lot. I mean, you're all talking 2.5 cases a day. I mean, how long do you give somebody the state or in defense to make their arguments, and then how long is it after that you hand down your decision?
So it's, there may be 1,000 cases, but some cases are more complicated than others. Some have, if there's a case that was tried for 2 or 3 weeks, that's going to be different than a case that was simply tried, maybe didn't even go to trial because a judge threw it out. So you sort of look at cases and they're all different, but we do have a lot. So cases don't get considered to be a case until the briefing schedule is completed. So by the time it comes to us, all the briefs that have been required have been filed before it's assigned to one of the justices to look at. We don't grant oral argument very much because a lot of times the parties don't want oral argument. So a lot of cases that are decided are really decided on the briefs that were filed, the petitions that were filed to us. And most of the cases are decided that way. There are some cases that we do have, oral argument for, and then after the case is orally argued, then we'll, render decision. It just, it's hard to say because you have cases that go all the way from a capital murder case. It could be a very intense trial over several weeks with mountains of evidence versus another case that could be neighbors disputing where the boundary line is. And, you can see that it's going to, some of those cases are easier to resolve, than others. But we try to decide cases within 120 days. I mean, we can do that. We typically, well, not typically, but we're required to file a report if there's been a case that's gone over 6 months, and we have to file a report and explain why it's taken us, so long to handle that case. And sometimes just, a very large case just takes more time to do it. But I think most of us try to get our cases out in a timely fashion. I was a lawyer in private practice for 28 years. And so I kind of look at that as the sooner we get cases out, the better it is, because clients and lawyers need to know what the law is and move on with their lives. And the sooner we can make a decision, the better it is for everybody.
I like it. I had one more. I read somewhere that only like 1.9% of cases are ever overturned on appeal. Have you ever heard any statistics on
I
how many get
haven't
over?
really. It's always hard to look at court statistics
Mm.
overall, because when you think about, there are a lot of cases that get filed and they get dismissed and they don't go anywhere. So it's hard to take. There's no such thing as your typical case. So the only thing you can look at is, for instance, I can look at the cases that are filed in the Alabama Supreme Court, and we can extrapolate information from those cases and see what they are. But it's hard to say overall for the court system, because there's so many cases that get filed that never really go anywhere. And the ones that we're looking at are clearly the ones that are a lot more complicated, because there are a lot of times that people just decide not to appeal their case, and you don't necessarily know why they didn't appeal their case. It could be that, well, they'd had enough, they didn't want to go any further with it, they just wanted certainty. So court statistics are always difficult because cases can be so technical, fact intensive, legally intensive, that it's hard to draw a particular statistical data point that applies across the board, because there's no such thing as your average case.
Well, Judge Sellers, you are a very intelligent man who articulated a lot of things to me that I, didn't understand, and or help me understand or comprehend better. Um, is there anything you would like for the people who watch to know about, Judge Sellers, or what incorporates your job
No,
that
I,
hasn't
I
been
really,
talked
I just,
about?
I appreciate the opportunity to talk about, what I do on a day in and day out basis. I think that the things that we can do to educate the public better about how their legal system works is important, because having a stable and consistent legal system is absolutely critical to Alabama's, place in the country. And we want to make sure that our laws are very clear, that our laws are stable, and that when people come before our court system, they know they're going to be treated with respect and they're going to be treated fairly. And even if they disagree with the result, and I've been there as a lawyer, when I didn't disagree with the result, if I felt like the judge treated me fairly and I got an opportunity to argue my case, that's the most you can ask for. And I think that that's the parting thing that I would want people to know, is that our job is to make you feel like you're respected, that you were listened to, and that we reach decision in your case in a as expeditiously as possible.
Judge Sellers, I'm not going to keep you any longer. I've had you on here for an hour, and I know you've got a lot of stuff to do. It's been a pleasure talking with you.
Thank you so
When I get,
much.
it may take me a day to get the article written because I'm backlogged right now. I don't know
Sure.
if I told you the blogs turned into a statewide thing now, so I've got a lot of work to do. But as soon as I get it up, I'll get it to you again.
Well, it was a
Thank you.
it was a pleasure to talk with you, and I hope to see you again soon.
Yes, sir, Judge. Thank you. You have a great
Okay.
afternoon.
Take care. Have a good day. Merry Christmas.
Merry Christmas.